It's the High Court on the judicial side has entertained a review and apparently gone beyond it on a mistaken impression, which is revealed at page 12. I'll just give your lordships the background. This is for 138 posts of civil judge, junior division, for which there were more than 21,000 candidates. Now, there was an amendment to the rules which permitted that the eligibility requirement is 3 years as an advocate and 70% marks. Yes, that amendment was challenged by waiver writ petition. It came up to this court, so on 15th of December, your lordships were pleased to dispose it on a submission that was made on our behalf, on the High Court's behalf, saying that those who do not meet this eligibility requirement will be permitted to file. So treat the amendment as non-effective, subject to the outcome of the proceedings challenging the amendment. Now, thereafter, the prelim exam is conducted. 926 individuals qualify in the preliminary exam. Then broadly, they will look at a 1:10 ratio. It became a little less than that. Out of the 926, 846 appeared in them. Yes. Of which 809 were general, 31 physically handicapped, etc., etc. Now, thereafter, on 30th March 24, the mains exam is held. Yes. So that exam has been conducted. Yes. Sticking to the original schedule which we had set out, on the 1st of April, this exam is held on 30th March. The next day, the High Court upholds those amendments to the rules. Yes. Now, because it was made subject, therefore, it requires an exercise now by us where we remove all those who did not meet the eligibility requirement under the amended act. So we have to weed out. Now, we are carrying out the weeding out process and sending those for the interview who do have the eligibility requirement. 2 individuals have filed a writ petition. The writ petition is dismissed at the outset. They file a review. Now, in the review, which is what the impugned judgment arises out of, please come to page 12. The 2 of them argue that they should have been permitted then to have been considered in that shortlist that was made for participating in the mains exam. Where is that? Page 12, para 11. Yes. To ensure purity and administration of justice, the least that is required is to prevent any ineligible candidate to secure appointment on the post of civil judge entry level. This is never going to happen. We are only going to ensure only eligible people as per the sustained amendment are the ones who are going to be appointed. So a review action, the exercise. Yes, something like that. Yes.
The eligibility bar, which eventually was upheld by the High Court,
yes,
pertain to either 70% marks or 3 years practice.
Correct.
Right?
Correct.
Now, the 2 who have filed the review petition,
yes,
which clause they don't fulfill?
They will be ineligible. Okay. They will fulfill this. We have no doubts on the eligibility.
Okay.
They will fulfill it. But because the entire exercise was made subject to the outcome, and there were no other interviews at that stage, we went ahead and had the prelims exam. Now, in the prelims exam, the entire pool, including these 2, took part.
Right.
There was a merit list drawn out of that,
right,
on which we have to shortlist out of this 21,000. We have to sort out who would qualify. 926 qualified. There's cutoff marks for each of them. So in the unreserved, the cutoff was 113. Yes. These 2 below 113. They fell below 113 marks as the cutoff because they're both general. There are different cutoffs based on the category, but in general they fell below 113.
Yes.
So therefore, the final list of 926 who had qualified for the prelims did not include them. Okay. Now those who did qualify in the prelims went and took part in the main exam, which was held on 30th March. They were not among them. But because a judgment came after the main exam and the judgment upheld the rules, they say, because you sent 926, which included those who were not eligible as per the amended rules, those people should have been weeded out. They should never have been sent retrospectively for the mains. We should have been sent. We would have had a chance to move up. One to be fair, would have been within firing range, 111 or so. The other was about 2 marks below that. So that is the case. So because we had already conducted the main exam from a pool, because there's no assurance that those two, even if they had come for the mains, would have qualified. We had conducted it, and we had, out of that 846 who appeared in the mains, we have another stage of an interview. So those who have done well in the mains, their mains marks and the interview marks will be taken into consideration. Now what they want and what they have succeeded in partially is to ensure that those who are eligible and have made it through the mains can remain as they are. But a separate exam now has to be held for those who will be remain after you weed out those who are ineligible. The only thing is to, bifurcate that process is a little difficult for us because we have to do an interview after this. So we are going to take one exam which has already been conducted, a new exam as per the impugned directions, to make those two people eligible for what? Not for the appointment, but just to contest a main examination. That is the case, Manoj. So in my view, in a review jurisdiction, perhaps the view that the court took, and I think it is premised on this para 11, believing that we would allow ineligible candidates to become, that would never happen. Out of this final list of 846 who appeared, Manoj, and took the mains exam, automatically nobody will be called for the interview who are not eligible. So there's no question of ineligible candidates being appointed.
It's perhaps the numbers may vary a little.
Numbers may vary.
Very a little.
Numbers may
So
vary.
beyond that, no ineligible person is going to get
No
into
question, no question, absolutely not. There's no question. So I think they misdirected.
And
Yes.
one candidate has got 112. Another candidate has